Hello viewers, welcome to the second episode of Legal Literacy series. As a continuation of our legal literacy episodes, this time we are looking into a complication that may arise relating to FIR. That is, when police refuse to register the FIR. If you go by the law, the police has duty to note down any information that is received by him, and the same should be treated as FIR. The police has no right to refuse any of the information on the grounds like non-reliable information, past hostility, concocted story, or even lack of jurisdiction. In support of this statement, Supreme Court has interpreted Section 154 of CRPC, and it has held that when the legislatures specifically talk about any information received should be written down and not reasonable complaint or credible information. That shows that the police is not under duty to check or find out the veracity of the information, but he is duty bound to note down. Therefore, FIR according to law cannot be refused. Regarding the same law, there is another viewpoint. If police are forced to record each and every information received as FIR, then it may lead to filing of false complaints, and false complaints may lead to harassment and exploitation. These false complaints can put police and court into misuse, by which personal vendetta could be settled by the people. The law is aware about such misuse. To avoid such misuse, the police is given discretion at the second level, that is, at the time of investigation. Police cannot refuse FIR, but police definitely can refuse to investigate any crime by giving reasons. Just now I explained the position of law, but the saying goes that what is in book and what happens in reality, there's a vast difference. Even though law prohibits refusal of FIR, it is possible that sometimes FIR might be refused. Then what? Every citizen runs the risk of refusal of FIR. Therefore, it is important to know remedy in case of refusal to register an FIR. The aggrieved party has 4 remedies in case of refusal. Firstly, Criminal Procedure Code provides a remedy of approaching a judicial magistrate. Secondly, under departmental disciplinary process, party can approach local Superintendent of Police. Thirdly, the parliamentary enactment has established National and State Human Rights Commission, and they could be approached. And finally, the party can approach an institution known as SPCA, State Police Complaints Authority. We will try to assess each of the options on its merits and demerits. The first remedy against refusal is provided under Criminal Procedure Code. Let us try to understand the procedure of this remedy. Section 200 of Criminal Procedure Code provides for another option of filing a complaint with the judicial magistrate. All offences needs to be registered with police with an exception of section 200. Sometimes a private complaint has to be filed where police do not have a direct authority to conduct investigation. In such situations, parties approach magistrate, file a complaint with him and ask for direction for investigation. This same section could be used in case of refusal of FIR. So if police refuse to register the FIR, then the parties can approach magistrate under section 200, register a complaint with the magistrate and seek a direction from the magistrate for investigation of the offence. Moving further, let us look into the second option, that is complaint to the Superintendent of Police. In case of refusal of registration of FIR, the parties can approach Superintendent of Police. This superior officer enjoys two important powers. First, the power conferred by Section 36 of Criminal Procedure Code, where SP enjoys all the investigative powers of a police officer. Such information that is given to the Superintendent of Police could itself be treated as FIR and the criminal justice system could be put into action. Secondly, the administrative powers of Superintendent of Police allows him to have a control over his subordinates to maintain efficiency and accountability in the department. Under this power, Superintendent of Police, instead of treating the information as a FIR, he may issue direction to the local police to conduct the investigation. Next option is reporting it to National Human Rights Commission or State Human Rights Commission. To give you a little bit of background about these commissions, these were established under the Protection of Human Rights Act 1993. National Human Rights Commission and State Human Rights Commissions are the commissions at the center and the state level. The commissions are established to protect the citizens from violations of human rights. Non-registration of FIR is a violation of human right. Therefore, a letter to Human Rights Commission will put commission into action and they would direct the police to register the FIR and investigate the crime. As the different states have their own State Human Rights Commission, the complaint could be made to their respective SHRCs. However, it is important to note that presence of SHRC does not mean National Human Rights Commission cannot look into the matter. Therefore, both commissions can exercise jurisdiction simultaneously. National Human Rights Commission allows any form of communications. The NHRC could be communicated by post, the address is given in the video. It can be communicated telephonically or by fax, both numbers are given in the video, or it can be communicated in an electronic form. The final option is approaching State Police Complaints Authority. SPCA is an authority established under the directions of Supreme Court of India, and this authority could be approached in case of refusal of registration of FIR. Once SPCA receives such information or complaint, it conducts an independent inquiry and passes recommendations to the state government for immediate action. However, it is important to note that all states have not yet established State Police Complaints Authority. Some of the states which have already established have kept retired High Court judge as a presiding officer. Some of the states have kept secretary as the presiding officer, and most importantly, SPCA itself cannot take action against the erring police officer. It can only recommend to the state government. The Home Ministry would take action on the recommendations of SPCA. Sadly, the recommendations of SPCA is not binding on the Home Department. It may refuse to take action. The most crucial question that is before us is, what should we do? We have 4 options before us. Which option we should exercise? Let us have a detailed discussion on the exercise of the option. I am going to present before you my opinion on these 4 options available before us. My opinion is based upon 4 different objective criteria. So I am going to call them as performance index. Some of you want quick remedy, that would be time factor. Second performance index would be the efficiency in providing relief. Third performance index is the result, the best result possible. And last one, most importantly, cost factor. Which option is cost effective? If time factor is taken into consideration, magistrate and superintendent of police are quicker in providing you with remedy, because immediately the police are put into action under the directions of magistrate or SP, whereas NHRC and SPCA, they take their own time because of the distance as well as because of the procedure adopted by them. So as far as time is concerned, first 2 options are better. As far as efficiency is concerned, the directions from magistrate would lead to registration of FIR as well as efficient investigation of the offence. Same thing cannot be said about directions from SP. No doubt FIR would be registered, but investigation won't be supervised by SP, therefore it cannot ensure efficient investigation. Directions from NHRC and SHRC, definitely being statutory bodies, being the bodies of national and state level, SP and even local police would definitely register the FIR and conduct efficient investigation. When it comes to state police complaints authority, the complaints authority would recommend to the state, and the state in turn recommend it to the local police. So therefore, efficiency may not be ensured all time. The third criteria is result. When these options are exercised, these could be exercised with 2 different objectives. Objective 1, to have efficient investigation of the offence. The objective 2 would be to create a fear of law in the minds of police so that such refusal are not repeated with others. In case of objective 1, where you want an efficient investigation of the crime, not only registration but investigation, then magistrate is going to be the best option, because he ensures investigation and most of the time he supervises the investigation. Reporting to SP, yes, registration is possible, investigation cannot be ensured. NHRC and SHRC, the best option, because they would definitely give directions and they expect submission of the report within a limited period. But same thing cannot be said about SPCA all time, because again it's the recommendation given to the state and the state may accept or may refuse. The last objective criteria is cost. Approaching magistrate is not cost effective, as you need to take the assistance of an advocate and he is going to charge fees. Superintendent of Police, you can go directly, make an application and ensure the registration of FIR. NHRC, again there is no third man involved in this whole process. You make a letter to NHRC and NHRC takes care of remaining processes. SPCA, Again, involvement of advocate is very limited. Parties can go on their own, represent on their own, but advocates are not prohibited. They can come and represent the parties. I hope the information shared in this video would be of some use to you all. Thank you very much for watching this video.